Let's talk about trusts. Trusts have become a popular method of managing assets, both during a person's life and after death. A trust basically is an entity that separates legal and beneficial ownership. This is a different definition than the book, by the way. It involves three people: the grantor, also called the settlor or the donor, who creates the trust and the fund and also funds the trust. The trustee is the individual who manages the assets in the trust, and the beneficiary is the one who receives the financial proceeds from the trust. Quick note on the trustee. The trustee technically actually owns the property within the trust, but he or she must use it for the good of the beneficiary. They act as an agent and they have fiduciary duties, and we'll talk about that a little later in the video. A grantor can create a trust during her lifetime or after her death through her will. There are 4 requirements for establishing a trust, either a trust that is done during lifetime or after death. They all have the same 4 requirements. The first one, just like a will, the grantor has to have capacity. They must be of legal age and of sound mind. The trustee, there has to be an appointed trustee. The grantor has to appoint at least one trustee. The grantor can also be the trustee. The trust does not end if the appointed trustee dies or resigns. Either the trust instrument itself provides for a successor, or the court can appoint one. So the trust itself doesn't fail. And then beneficiary. The trust has to specify a specific beneficiary. Don't necessarily need a name of an individual. Certainly you can, Mark Jones is the beneficiary. Could actually say a name, but it could just specify a class of people. Living children of the grantor, right? They can be identified. We can figure out who the children are of the grantor. But probably saying this trust is for my best friends, that might be too vague. That'll be a little hard to figure out who that class of people are. Is. And then trust property. The grantor must transfer specific assets to the trust. You start a trust, you have a trust document, but you actually have to have property within the actual trust. So what are the advantages of a trust? Let's go through some of those. Control. The grantor can control her assets after her death. She can decide who gets what and how much. So for example, suppose the grantor has a husband and children. She wants to provide her husband with adequate income after her death, but she does not want him to spend so lavishly that there's nothing left for the children. Nor does she want him to spend all her money on his second wife. So grantor could create a trust in her will. She would create it in her will that allows her husband to receive income, and upon his death gives the remainder to the children. So that could be a very perfectly good trust that's built right into the will. And we'll talk about specific types of trusts in a little bit. Leona Hemsley, I don't know if you're familiar with that name, from the 80s, early 90s. She, and check out this, there's a TV, if you're interested in this kind of stuff and celebrity wills, TV series. I found it on Tubi TV. Life, Death, and Money is what it's called, and it's all about celebrity estate battles. Aretha Franklin's is on there, George Hemsley's on there, Tom Petty, Whitney Houston, Selena, Stanley, and Leona Hemsley. And it's kind of sensational, but the information about the wills is pretty accurate. But she left $20 million in a trust to her dog and didn't leave anything to one of her grandchildren. And she made very specific rules regarding when the other grandchildren could get the money. They had to visit their father's grave, I think, once a year. So she basically set up her estate so that she can actually control her assets, from the grave. Interesting story. Number 2, caring for the vulnerable. So minor children, they cannot legally manage property on their own. So parents and grandparents often establish trusts to take care of assets until the children are of age. Older adults and people who are disabled may also need protection from, potentially financial predators. Think of legal guardians. If you leave as we talked about wills, and you appoint a guardian for the children, but if you leave money to the guardians and you hope that they're going to use that money to care for your children, they don't technically have to. So you set it up in a trust, right? That's how that would be controlled, that to ensure that the money goes to the children and not to the guardian. Tax savings. Well, like I said, tax issues are outside the scope of this class. It is worth noting that trusts can reduce estate taxes. For example, grandparents can establish what's called generation skipping trust to reduce their estate tax bill. There could potentially be tax repercussions on the receiving side of that, but as I said earlier, one of the big reasons for estate planning is to kind of minimize taxes, and most of the time it's the person, the testator or the grantor, who are thinking about their own tax situation. Privacy. A will is filed in probate court, and court is a place of public record. So the will itself becomes a matter of public record. That's why we hear about all these celebrity wills, because then they, especially if they go to a battle, they go to probate court, and all of those records are public. Trusts, however, are private documents and are not available to the public. So privacy is an advantage. Probate, because a will must go through the lengthy probate process, the heirs may not receive assets for some time. Assets that are put into a trust before, and I know this is before the grantor dies. It's another issue when the grantor puts a trust within the will. We'll talk about that. But assets that are put into trust before the grantor dies do not go through probate. The beneficiaries have immediate access to them. Number 6, protecting against creditors. Now, this is not universal. New York State does not recognize this component, but the states that do, this is certainly an advantage. About a third of the states, they permit what's called a domestic asset protection trust. Creditors have no right to reach any assets that a donor has placed in one of these trusts, if they've created one of these trusts. But the donor, the grantor, can still spend the money as long as he has the trustee's permission. So that's kind of the downside to this, but here's an example on how this works. Let's say Carmen has an unfortunate alcohol and drug problem, but he's also pretty swift. When he inherited millions on his 21st birthday, he placed them all in a domestic asset protection trust. Later, he marries, had children, and got divorced. He also was in a car accident that caused the death of a young investment banker. When his ex-wife and the banker's husband sued him, neither of those people can get his assets if successful, because his assets are protected from all creditors if put in that domestic asset protection trust. But the downside, he can only spend trust assets with the trustee's permission, and they may not always agree on what constitutes a reasonable payout to him. Like if he wanted to go on some, grand vacation that was going to cost, I don't know, $50,000, $60,000, that might not be something the trustee would consider reasonable. So the trustee would control and need to provide permission, but not recognized in the state of New York. Disadvantages, there's one, but I made it look like there's more than one. It's expensive. Legal fees, you have to create the trust and establish the trust. Creating the legal documents can be certainly voluminous and time consuming. The trustee, if the donor is not the trustee, you have to pay trustees fees regularly. That's an expense, and sometimes it results in higher taxes depending on the type of trust it is, what kind of assets are in that, who's the beneficiaries of the trust. So We won't go into the details of taxes relative to trust, but you should know that it can actually be an advantage and it can be a disadvantage. But it is much more expensive to create a trust, especially if there's a lot of assets involved. And folks who have lots of money and assets do take advantage of this because of the estate having estate taxes wouldn't go into probate and pass through either intestate laws or through the will.